Welcome to this training on data privacy. In this video, we will cover the following topics. What is meant by data privacy? What is meant by personally identifiable information? Why is this relevant for our school? What are the key risks and challenges? And how can your school better protect your data and comply with legal requirements? Data privacy, also called data protection, is about making sure that you are being fair and responsible when processing people's personal data. These people could be students, parents, prospective students, alumni, or members of the public. They include people in your country, as well as potentially people in other countries. It also includes yourself and your colleagues, which means that your school should take steps to make sure that your personal data is also processed appropriately. Before continuing, let's define some common terms. First, what do we mean by personally identifiable information? Generally speaking, personally identifiable information, also called personal data, is information that relates to a specific individual. This covers basic identifiers such as name or email address, as well as more confidential information such as salary details, disciplinary records, or bank account information. In some countries, certain types of data are recognized under law as sensitive and include information such as medical data, criminal records, religious beliefs, or political opinions. Personally identifiable information can be in an electronic format, such as a spreadsheet concerning student information, or closed-caption television footage of a classroom, or paper records, such as paper report cards. So what do we mean by processing personal data? In this training, we'll talk a lot about processing personally identifiable information, but what does processing mean? We use processing as simply a catch-all term to describe all the things that could be done to personal data. It includes collecting, recording, organizing, structuring, storing, using, handling, deleting, or archiving, among many other actions. Different laws use different terms to describe these activities, so in order to simplify things, we'll just talk in terms of processing. It's a word that's commonly used in data protection laws and by privacy professionals. Just know that it means doing something with personal data. Here are some examples of processing. Collecting names and addresses of people interested in hearing more about your school. Storing resumes and application forms from job seekers. Recording videos of people with CCTV surveillance cameras. Organising parental consent forms into a filing cabinet. Archiving records of safeguarding data. Transferring examination records to another organisation. Sending information to the personal email addresses of alumni about social events. Sharing vital medical records with health professionals. Or taking photographs or videos of people. These are just some examples of processing personal data. In short, doing almost anything with personally identifiable information could be described as processing, and thus could be regulated by law. So what is meant by appropriate use of personal data? Schools and other organisations have a responsibility to process personal data in an appropriate manner. But what do we mean by appropriate? There are a number of aspects involved. First, it means being lawful. There are hundreds of laws across the United States, both state and federal, which create specific obligations pertaining to data protection. Many of these laws likely apply to your school, but beyond that, there are also laws from other countries which, in certain limited circumstances, could also impact your school. Collectively, these privacy laws create requirements which identify how data should be collected, to whom it can be shared, how long it must be kept, and how it must be destroyed. The first priority is to ensure that all processing of personal data is lawful. In addition to ensuring that your school is processing data in a lawful manner, appropriateness also refers to satisfying your school's internal requirements, included in your own standards, policies, and procedures. These are often created to ensure that your school satisfies all legal requirements, but they can also go above and beyond what is legally required. These may cover things like how your school obtains personal data, where it is stored, and who is allowed access to it. Therefore, the second priority is to ensure that processing meets the internal expectations of your organisation. The legal requirements, together with your organisation's policies, will include specific, objective rules on what is expected, but they will also have expectations that are harder to quantify, such as considerations for ethics, safeguarding, welfare, and respecting people's right to privacy. So given that, what does handling personal data in an appropriate way mean? In practice, handling data in an appropriate manner generally means being open and transparent about how people's data is processed and why it's needed, processing the minimum amount of personal data necessary to fulfill the purposes for which it was collected, ensuring that appropriate security and controls are in place to prevent that data being mishandled, taking responsibility for data that belongs to other people and safeguarding it while it's under your control, building trust between your organization and the people whose data is processed, or recognizing that people have a right to control over their personal data, while striking a balance with the needs of your organization and wider society. The availability of information and ease of transfer has changed dramatically over recent decades. Individuals' personal data is moving to and from countries in ways people don't often realize or don't understand. For example, a person posting a social network picture can mean that the information is transferred from their computer or phone to a server in California immediately. From there, it may be disseminated to hundreds of users in countries worldwide within seconds at the tap of a screen. Each person who likes a picture can share or resend the picture to many others with little or no restrictions. Meanwhile, the original picture can be easily modified, saved, shared, or uploaded to any number of other internet sites. These days, information is not only easily transferred, but also difficult to control. Not only is the ease of information sharing a desire for consumers, it's also big business. Social media companies, retailers, and advertising agencies are just some of the many organizations that benefit from processing the personal data of their users, customers, or potential consumers. In the face of increasing concerns about how personal information is used or even monetized, lawmakers across the world are establishing restrictions on how personal data is processed. But legal protections of personal data are not new per se. Protecting personal information has a long history in the United States. For example, going back to the late 19th century. From a slow start, the international legal landscape has changed dramatically, with new laws and regulations being drafted and enacted throughout the world, including in the United States. In the United States, your personal information is protected in many ways. There are constitutional protections, there are standards which are enforced by courts, known as common law, such as protections against invasion of privacy, and there are hundreds of federal and state laws as well. The important thing to know about these laws isn't just that they create certain requirements, but also that new laws are being enacted every day. As data threats, such as cyber attacks, evolve, privacy laws evolve as well. Up until 2 or 3 decades ago, many states did not have any privacy laws, but today, every state in the United States has at least one law which governs how data must be collected, handled, protected, or destroyed. Some states, like California, have multiple laws. For example, in 2018, California passed a law called the California Consumer Protection Act, or the CCPA. Although that law only came into effect in January 2020, California voters nevertheless approved Proposition 24 in November 2020, which enacted the California Privacy Rights Act, the CPRA, which expanded the protections covered in the CCPA. It is important to note that the CCPA and CPRA do not generally apply to non-profit educational institutions. Nevertheless, there are exceptions which might make those two laws apply to your school. For example, the CCPA and the CPRA may apply if a school is controlled by or shares common branding with a for-profit entity, subject to those laws. Regardless of whether or not CCPA and CPRA applies to your school, there are multiple other laws which do apply, and which create requirements for how your school processes personal data. Applicable laws may include, but are not limited to, the California Security Breach Notification Law, the California Social Security Number Law, and the California Online Privacy Protection Act of 2003. Furthermore, in some circumstances, the laws of other countries may apply as well. For example, if a school in California processes the data of alumni living in Europe, then the EU's General Data Protection Regulation, or GDPR, may apply. This will be the case even if that school has no physical presence in Europe. Similarly, if your school's student body includes students who are Chinese nationals, it's worth noting that China has recently drafted a law which could also impose certain obligations regarding how you process those students' personal data. In order to get a better grasp of which laws apply to your school, and what those laws require you to do, we recommend that you speak with legal counsel. Additionally, Sine can help you on your compliance journey with our app and consulting services, discussed later in this video. While ensuring legal compliance is one important reason for a school to focus on data protection, there are other reasons as well. Firstly, cyber attacks. Increasingly, cyber attackers are targeting schools. In December 2020, the FBI and other US authorities issued a joint warning that hackers are targeting kindergarten through 12th grade educational institutions, leading to ransomware attacks, the theft of data, and the disruption of distance learning services. Reputational damage is also a serious risk because schools are expected to look after children's data in an ethical and responsible way. There are few organisations that process as much data about children and minors as schools. The personal data of young people is rightly afforded special protection in many data protection laws. The exposure of personal information of young people can have serious consequences to those children, especially if it is related to safeguarding, welfare, or health information. Consequently, any unlawful exposure of such personal data may have drastic effects on a school's reputation. Cyber attacks, accidental disclosures, and data breaches can lead directly to financial losses. These include the administrative time and operational costs needed to respond, repair, and restore services that have been attacked or breached. There are also indirect financial effects, such as the cost of reputational damage. There can also be fines and penalties for data breaches or unlawful processing, imposed by data protection regulators or law courts. For example, in 2019, an Illinois-based operator of several post-secondary schools was ordered to pay $30 million to settle Federal Trade Commission charges that stemmed from their employees making calls to consumers on the National Do Not Call Registry, promoting enrollment in their post-secondary schools. In another case, in 2016, an investigation by New York's Attorney General discovered that certain websites operated by US companies were using tracking technology that illegally enabled third-party vendors to track children's online activity without consent. That case resulted in a $835,000 settlement for violations of the Federal Children's Online Privacy Protection Act, or COPPA. Let's take a look at some other examples of recent data protection court cases. In 2018, an educational institution in Mississippi was ordered to pay a former employee $200,000 in response to the former employee's claim that the school invaded her privacy when it disclosed confidential information about the former employee to a local newspaper. In another situation, a former IT system administrator for a private college locked the college and its 2,000 plus students out of their respective school Google accounts and refused to provide the sole administrator login information, which only he possessed, to unlock those accounts unless the school paid him $200,000. The school and the students were only able to regain access over 6 months later. The school sued the former employee, and in 2020, a court ruled that the former employee was ordered to pay $450,000. In both cases, the respective education provider could have better protected itself through stronger data protection policies and procedures, and increased adherence to data protection laws. Thus far, we have discussed the basics of data protection and why it's important for various reasons. We will now consider what actions are required to meet legal requirements. In other words, what does your school need to do to ensure compliance with data protection law? What are the practical steps that must be taken to meet legal requirements? You might think that it should be straightforward, or that the law directly states what is required, but in fact many data protection laws are ambiguous, insofar as many don't typically specify how compliance should be achieved. Rather, they focus on vague standards that must be satisfied. Moreover, schools are required to satisfy different obligations from different laws, which might be tough to manage. All of this collectively highlights the benefits of adopting and adhering to principle-based policies and procedures to both satisfy existing legal obligations as well as protect against foreseeable legal changes ahead. So where do we begin? Since data protection law is about protecting people's personal data, it is important to think about what you are doing with the personal data in your possession. What personal data do you collect? Why do you need the data? What do you do with the data? Whom do you share the data with? Where do you store the data? Who has access to the data? How do you secure the data? How long will you keep the data? How do you inform people about what you are doing with their data? And how do you destroy or archive the data? These questions will help you identify the personal data lifecycle and how data can be processed in multiple ways, from collection to destruction. To help your school answer these questions and map out data protection compliance needs, Nine Consulting has created a data privacy framework. Nine is a global data protection consulting and edtech company with offices in Europe and North America. For over 10 years, independent schools have been our sole focus. Our data privacy framework sets out 9 core areas that are generally required in a data protection compliance program. The framework is relevant for any organization, whether small or large, and is globally applicable. The first item in the framework is leadership and governance. Accountability for data protection compliance starts at the highest levels of the school's management. A coherent strategy and clear goals should shape the organization's intentions and results. Well-defined roles and responsibilities should be assigned to individuals. Regular reporting and reviews enable visibility for senior leadership. The next item in the framework is record of processing and data mapping. Understanding what, why, and how personal data is processed will help the organization establish what risks exist and provide a basis for compliance. Understanding the personal data lifecycle and what happens to personal data under your control will enable clearer visibility of what the school is doing with people's data. Incident and breach management. Processing personal data inevitably results in risk. Data can be deleted, disclosed, modified, or lost in unlawful ways, either accidentally or deliberately. Mishandling or misuse of people's personal data can lead to serious consequences. A data breach program establishes processes and procedures to reduce risks, as well as enabling the organization to respond and react appropriately in the event of an incident. Information rights and data ethics. In many countries, people have legal rights to their personal data. Even if they don't, organizations should adopt a fair, reasonable, and ethical approach to processing their data, ensuring that individuals have a general right to privacy, as well as appropriate information and access to their data is an important part of an ethical data protection program. Training and awareness. Enabling staff to identify and understand their role in data protection is a vital component. The goal is to help people handle personal data appropriately and do so with confidence and assurance that help is available and that they are supported by senior management. Training and awareness is also a continual necessity. It must be relevant, accurate, and up to date, as well as easily available and understandable to those who need it. Data sharing and contracts. Personal data is often transferred from one organization to another. Sometimes data is sent internationally to other countries. This can include sending data to vendors, third parties, public bodies, or other organizations. In some countries, appropriate contracts and measures must be in place for such transfers to take place lawfully. Even where this isn't applicable, managing the agreements, contracts, and arrangements between your organization and other parties is a core part of a responsible approach to data protection. Information security and operations. Information security supports effective data protection. Ensuring the right levels of confidentiality, integrity, and availability will protect personal data and ensure that access to it is appropriately controlled and logged. Since most personal data is stored and sent in electronic form, the underlying software, hardware, and networks should be designed and implemented with security as a central concern. Risk management and controls. Risk is inevitable for any organization that processes personal data. How effectively that risk is managed is an indicator of the effectiveness of a privacy program. Wherever possible, you should try to reduce, mitigate, or eliminate the risk of personal data being mishandled, misappropriated, or misused. Establishing and maintaining an effective data protection risk management program is a necessary element in a compliance program. And finally, policies and notices. Appropriate data protection cannot be based on ad hoc or impromptu actions. Formal policies and procedures should be clearly written, regularly reviewed, and widely disseminated in order to establish and maintain the organization's expectations for how personal data is processed. Meanwhile, information should be clear and readily available to data subjects. 9 supports schools with our education-specific data protection frameworks, delivered via our modular toolkits. These toolkits will guide your school through a journey of compliance progression, including best practice resources, policies, and templates. If you would like to download our toolkit or speak directly with one of our consultants to understand how 9 could assist you, feel free to get in touch via support@9.com.